Hi, this is Sean Henricksen here at the Sean Henricksen Law Firm, where we help good people like you avoid the devastating consequences of criminal charges. Today, we're going to be talking about outcry statements, which are certain types of statements that may be able to be brought into trial when they normally wouldn't otherwise be allowed in if it weren't for this rule. Before we get to that, we do have a free download for you. It's 5 things that you should be doing right now if you've been arrested. If you look down in the description, we've got a link there. If you enter in your email address, we will send that right out to you. An outcry statement is basically a statement made by somebody who's 14 or younger to somebody else other than a law enforcement agent normally, but it really could be anybody that they make the statement to, as long as it's the first person that they tell about it. And it's going to be a statement about whatever, incident happened to them. Typically, we see them a lot in sexual assault cases. A child will reach out to a teacher or a parent or, even like an uncle saying that they've been sexually assaulted. And that statement will be able to be brought into court. But it can be used on any type of assaultive case. It doesn't have to be a sexual assault. It can also be an assault of a child or any other type of assaultive case. Normally, hearsay rules would prevent that type of statement from coming in. So if I had been assaulted and I call the police and I tell the police that I was assaulted, that statement to the police wouldn't come in at trial. I would have to show up at trial and testify about what happened to me, about how I was assaulted. And the video or whatever there was of me telling the police officer would not come in. With this exception, though, it allows those statements to other people to come in as well. There are certain requirements to an outcry statement before it will be allowed in court. And that statement has to be a statement describing the alleged offense, and it has to be the statement made to the first person over 18 years old about what happened. Sometimes you can have multiple outcry statements. So if I tell somebody that I was sexually assaulted, and then I tell another person, let them know that I was assaulted, but I have more details. When that victim adds more details, then sometimes you can have multiple outcry witnesses. If the state is going to be the one calling that outcry witness, they've got to give notice within 14 days before trial that they're going to be calling this outcry witness. And they've got to give the name of this outcry witness to the defense. And they also have to give a statement of what the outcry statement is going to be. That way the defense has some notice about, what to expect and what the outcry statement is going to be. In addition to giving notice to the defense, there has to be a hearing where the judge finds that there is some reliability on that outcry statement. And the witness has to be the victim, the minor, or it could be a person with a disability also. They actually have to be available to testify, or they have to testify one of those two as well. We have had a couple of cases also where the state hasn't properly followed the protocols that they need to in order to call an outcry witness. A little over a year ago, we had a case where a client of ours was being charged with sexual assault of a child. And the state wanted to call an outcry witness, but they told us, I think it was just 1 or maybe 2 days before trial, that they intended to call this witness as an outcry witness. We didn't even have to have a hearing on it. We let the judge know that we weren't properly notified that the state intended to call that person as an outcry witness, and we were able to keep them from testifying and from bringing in that outcry statement. There was another situation where we had a assault of a child case. And again, the state didn't properly notify us that they intended to call a witness as an outcry statement. And so we were able to keep some of those statements out. And in the end, when the state doesn't do what they're supposed to be doing in order to call an outcry witness, then it's our duty to make sure that witness doesn't testify as to any of those outcry statements. If you have any questions about outcry statements, or if you're being charged with a crime here in San Antonio, feel free to give us a call or click the link down below to schedule a free consultation. Our phone number is 210-942-4997, and we hope you have a great day.